New York City Institutional Abuse History. Why New York City GMVA lawsuits matter. Attorney Andrew M. Stengel. New York City carries a long and documented history of institutional sexual abuse and of the concealment that made it possible. The Catholic Archdiocese, Columbia University Medical Center, the New York City Department of Education, and city run detention facilities have all faced evidence of systematic abuse and systematic failure to act. Understanding this New York City institutional abuse history matters beyond the historical record. Civil litigation has been the mechanism that forced these institutions into public accountability, producing document disclosures, policy reforms, and financial reckoning that neither criminal prosecution nor internal review could have achieved on its own. The New York City Gender-Motivated Violence Act's look-back window exists because of this history, and the July 29, 2027 deadline is approaching fast. A pattern of concealment across New York City's largest institutions. Three of New York City's most prominent institutions have faced civil lawsuits exposing decades of deliberate concealment, each following the same basic pattern of protecting abusers over survivors. The Archdiocese of New York confronted lawsuits documenting clergy abuse stretching back to the 1950s. Internal records revealed that priests were transferred after complaints rather than terminated. Civil litigation forced the disclosure of documents that the Archdiocese fought to keep private. The financial exposure those lawsuits created drove structural reforms, including independent review boards and new clergy supervision protocols, that internal processes had never produced. At Columbia University, Dr. Robert Haddon abused hundreds of OB/GYN patients over 2 decades. Survivors' lawsuits established that Columbia had received complaints for years before his termination. Rather than report him to authorities, the institution allowed him to resign quietly and signed confidential settlements with early complainants. Civil litigation produced accountability. The criminal justice system alone, despite ultimately convicting Haddon, could not have delivered. The New York City Department of Education has faced a documented pattern advocates call passing the trash. Accused teachers were transferred to new assignments instead of being terminated and reported. Civil lawsuits forced disclosure of personnel records, produced significant settlements, and created pressure for policy changes that the DOE's own internal processes had resisted for decades. Rikers Island detention facilities and the origins of the New York City GMVA. The sexual abuse of incarcerated individuals at Rikers Island and other New York City detention facilities is the subject of ongoing civil litigation. Federal law, the Prison Rape Elimination Act, PREA, imposes specific obligations on detention facilities to prevent, detect, and respond to sexual abuse. Civil lawsuits combining PREA-based theories with New York City GMVA claims may be available to survivors of detention facility abuse in New York. The cases that drove the passage of New York City Administrative Code. Section 10-1, 104.1 arose directly from this context. Hundreds of survivors of juvenile detention abuse had earlier lawsuits procedurally extinguished, time-barred before they could be heard on the merits. The GMVA look-back window exists because legislators recognize that institutional abuse survivors rarely come forward within conventional filing deadlines. Trauma, power imbalances, and institutional concealment all slow that process. That recognition became law, and it created a final window that closes on July 29, 2027. What civil litigation achieves, that other processes cannot. Financial recovery matters enormously, but civil litigation delivers far more than money. Institutional sexual abuse lawsuits have produced public disclosure of records that institutions fought hard to keep confidential. They have generated policy changes protecting future students and patients, professional accountability for leaders who enabled abuse, and public acknowledgement of survivors' experiences that no other forum provides. Civil discovery, the legal process of demanding documents and testimony from the other side, has exposed internal communications revealing exactly what institutions knew and when they knew it. No criminal investigation and no internal review produce that level of compelled disclosure. Additionally, each successful lawsuit creates legal precedent that makes the next case easier to bring and harder for defendants to defend. Furthermore, the financial and reputational costs imposed by litigation change institutional behavior in ways that internal reform rarely achieves. Civil lawsuits make concealment costly. That is precisely why institutions spend so much fighting them and why filing matters. The New York City GMVA's final window, July 29, 2027. The New York City GMVA's Section 10-1104.1 lookback window is the final opportunity to file civil lawsuits against institutions that enable gender-motivated violence in New York City before January 9, 2022. For some survivors, this is the last chance to hold institutions financially and publicly accountable for decisions made long ago. Decisions to protect abusers, silence survivors, and preserve institutional reputation over human safety. July 29, 2027 is not just a legal cutoff for the New York City GMVA. It is the last moment these institutions can be made to answer for what happened. When the window closes, it closes permanently. Survivors who have spent years deciding whether to come forward are running out of time. An experienced attorney can evaluate whether a viable lawsuit exists, even if the abuse occurred decades ago. The law firm of Andrew M. Stengel, PC, can evaluate your case. The New York City GMVA deadline is real, and it is approaching. The law firm of Andrew M. Stengel, PC, represents survivors of institutional sexual abuse in civil lawsuits throughout New York. Our firm understands the New York City GMVA, the institutions involved, and what it takes to build a case that demands accountability. Every consultation is free and completely confidential, and you pay nothing unless we recover for you. Contact us for a free, completely confidential consultation. Email info@stengellaw.com. For more information, please visit our website, stengellaw.com. Attorney advertising. Prior results do not guarantee a similar outcome.